In May 2010, a manufacturing company lost millions in a fire and reached out to their insurer for help, but instead of a check, they got arrested. This is exactly what happened in one of Ghana's most fiercely contested insurance battles, and the lessons left behind are ones that every business owner and ordinary person needs to know. Expom Ghana Limited had taken over Trusty Foods Limited, a tomato paste manufacturer. With that takeover came an inheritance, a sweeping all-risk insurance policy held with Vanguard Assurance. Buildings, machinery, stocks, and even product liability was covered under that policy. Vanguard knew about the change in ownership and accepted Expom's premium of 50,000 euros per annum, and in return, it stood on the hook for up to 15 million euros. Everything seemed in order, but then came May 2010. A fire tore through Expom's premises, destroying goods worth nearly 4.9 million euros. The fire service conducted its investigation and reached the conclusion that the fire started from an electrical fault. It was a tragic accident, but that was what the evidence pointed to. Expom did what any policyholder would do. They gathered their documents, composed themselves, and wrote to Vanguard. They wrote again, and they waited. But what came back was not a claims form. It was a police report. Vanguard had walked into the police CID and accused Expom's directors of arson and fraud. The directors were arrested, questioned, and released on bail. It was only after that drama that Vanguard put their refusal in writing. They formally declined to pay a single pesewa. Expom sued. They dragged both Vanguard and their insurance broker, TM Star Insurance, into court and demanded to be made whole for their losses. Vanguard came loaded with arguments. They said that they had no contract with Expom. Their deal was with Trusty Foods, making Expom a complete stranger to the agreement. They claimed the goods that were destroyed were already expired or close to expiry. They insisted that the whole thing was a sophisticated fraud, that Expom had deliberately set fire to cash in on the policy. And they pointed to two specific contractual issues. There was a clause excluding liability where the loss was a result of willful negligence of Expom staff, and there was also a requirement that watchmen be present on the premises at night. On the last point, they had very good ammunition. Expom had employed 11 security officers and then let all of them go, replacing them with a driver and a carpenter, particularly on the night in question. The CCTV cameras also happened to not be working that night. From Vanguard's perspective, the whole thing smelled fishy. The High Court, however, disagreed. It ruled in Expom's favor, and the broker escaped liability on the legal principle that the broker is not an agent of the insurer. Vanguard appealed. This is where things got very interesting. They attached a brochure to their appeal documents, a brochure that had never been tendered as evidence during the original trial. That brochure used the phrase security personnel rather than watchmen. The Court of Appeal latched onto those two words. Security personnel, the Court of Appeal reasoned, implied that they were trained individuals capable of protecting valuable property. It simply meant that a carpenter and a driver did not qualify. On the strength of that single phrase, the Court of Appeal overturned the High Court's decision and ruled in favor of Vanguard. Expom was upset and they were not done. They took the matter on to the Supreme Court. The justices of the Supreme Court took a hard look at what had actually happened and identified two critical problems with Vanguard's position. First, the brochure. The brochure had never been part of the original evidence, so it could simply not be smuggled into an appeal. The actual insurance contract used the word watchman, nothing more, nothing less. There was no agreed qualification, no training requirements, and no specification about who a watchman would be. The contract said watchmen, and Expom had two people on the premises, and that was the deal. Second, the fraud and arson allegations. The Supreme Court was not particularly moved by Vanguard's suspicions, however numerous and logical they seem to be. Allegations of crime are very serious and require serious proof. The fire service had said the issue was caused by an electrical fault. The police, after their investigations, had not secured the prosecution of any one of the Expom directors. Vanguard's own expert had visited the scene 2 years after the incident, and therefore his credentials could not paper over that gap in time. As the court made clear, a multitude of suspicions is not evidence, it was just suspicions. Vanguard lost comprehensively, and they were ordered to pay 4.9 million euros with interest at the commercial rate. Two lessons stand above the rest. The first is about precision of contracts. Insurance agreements are read strictly and literally. When Vanguard agreed to require watchmen, they did not specify trained security personnel, licensed guard, or certified professionals. They wrote watchmen, so when the dispute arose, that is exactly what the courts held them to. Every word in the contract carries weight. The second is about the burden of proof. Fraud is one of the most serious things you can allege against another person. It requires more than a suspicious set of circumstances. Expired goods, a replaced security team, broken cameras, individually and even collectively, these are circumstances that indeed raise eyebrows, but they are not proof. The moment Vanguard chose to play the fraud card, they accepted the burden of proving it, and they could not meet that burden, and it cost them dearly. When you sign a contract, read every word. When you make an accusation, bring your evidence. Anything less, as Vanguard discovered, is a very expensive mistake. Follow Super Law GH Studios for more real stories, real cases, real people.